One word. That is what the entire fight in this case actually came down to at the Supreme Court on June 25, 2026, in a term already packed with major rulings on immigration, guns, and executive power. Not a debate over immigration policy in the abstract, not a referendum on whether a particular country is safe or dangerous, one specific word in one specific federal statute, the word determination, and how far it reaches. Depending on how 9 justices read that single word, either federal courts retain some ability to check a cabinet secretary's power over hundreds of thousands of people's legal status, or they do not at all, ever, for almost any reason. The court picked the second reading 6-3, and if you have any connection to elder care in this country, as a family member, a worker, or an administrator, that single word just became one of the more consequential pieces of legal text in your professional or personal life this year, whether you have heard of it or not, and whether the video titles currently circulating about it bothered to get the basic mechanics of what a Supreme Court ruling actually is correct or not. Quick housekeeping. I break down Supreme Court rulings the way lawyers actually read them, not the way headlines compress them. And I focus specifically on the ripple effects that reach ordinary people, seniors and caregivers in this case, that most legal coverage skips entirely. If that is useful, subscribe and turn on the bell because this ruling is still working its way through implementation, and there is more coming. 2 seconds, and let's get into the actual legal mechanics because they matter more than the politics surrounding this case. Start with the program itself because you cannot understand the ruling without understanding what was actually being fought over. Temporary Protected Status, TPS, is a federal immigration category Congress created in 1990, specifically designed to give people from countries suffering war, natural disaster, or comparable extraordinary conditions a legal right to remain and work in the United States for as long as those conditions persist back home. It was built explicitly as temporary relief tied to conditions in a foreign country rather than to anything about an individual's specific case. Haiti was designated in 2010 after an earthquake killed or injured hundreds of thousands of people. Syria was designated in 2012 in response to the government and military's violent repression of its own civilian population. The law gives the Secretary of Homeland Security the authority to periodically review conditions in each designated country and decide whether to extend, redesignate, or terminate that status, a design that concentrates enormous discretion in one office, checked, in theory, by the possibility of judicial review if that discretion is abused. It is worth noting that TPS was never intended to function as a long-term immigration status in the way it often has in practice. It grants neither a path to a green card nor to citizenship on its own, and a decision to end a country's designation affects every TPS holder from that country simultaneously and uniformly, regardless of how long any individual person has lived here, how established their family or career has become, or how much they have paid in taxes during that time. That uniform countrywide structure is precisely what makes a single statutory interpretation question how broadly to read the word determination capable of affecting hundreds of thousands of individual lives through one ruling in one case. That theoretical check is exactly what this case tested. Last year, then Secretary of Homeland Security Kristi Noem, acting at the direction of the Trump administration, moved to terminate TPS for both Haiti and Syria, asserting that conditions in both countries had improved sufficiently. Haitian and Syrian TPS holders sued in separate cases, and their legal theory was not simply that the Secretary reached the wrong conclusion. It was that she failed to follow the process the statute actually requires, including adequate consultation with other government agencies before acting, and in the Haitian case specifically, that the decision was motivated by the racial composition of Haiti's population rather than a genuine assessment of country conditions, an equal protection claim under the Constitution. A federal judge in Washington, D.C., Judge Anna C. Reyes, sided with the challengers in February, finding the Secretary lacked the authority to terminate the designation the way she did, and that the stated rationale did not hold up. A federal appeals court reviewing the Syria case reached a similar result, characterizing the administration's approach as part of a broader pattern in its immigration enforcement strategy, and refused to pause its own ruling. The government sought Supreme Court review, and rather than simply rule on an emergency application, the court granted certiorari before judgment, meaning it agreed to decide the full merits of the case directly, rather than waiting for the normal appeals process to finish, a relatively unusual move that signals how significant the court considered the underlying legal question to be. This procedural choice is itself worth noting for anyone trying to gauge how the court viewed this case going in. Certiorari before judgment skips at least one full layer of appellate review that would ordinarily happen first, and the court reserves it for cases it considers urgent enough or nationally significant enough to resolve quickly rather than let percolate through multiple circuit courts over a year or two. The court took that same unusual step in only a small number of cases this term, which tells you the justices recognized early on that hundreds of thousands of people's legal status hung on how quickly this particular statutory question got answered. Oral argument was held April 29, 2026, and the ruling came down 8 weeks later. Now, the actual legal mechanics, because this is where most coverage of this case gets lazy and just reports the outcome without explaining how the court got there. The relevant statute contains a provision barring judicial review of any determination by the Secretary of Homeland Security regarding a TPS designation. The entire case turned on how broadly to read that one word. The challengers argued determination should be read narrowly, covering only the Secretary's final decision itself, which would leave room for courts to review whether the process leading up to that decision followed the law. Justice Samuel Alito, writing for the majority, rejected that narrower reading. He reasoned that every specific step in the Secretary's process, her choice of how and whether to consult other agencies, her assessment of country conditions, each individual judgment call along the way, is itself part of what led to her final determination and therefore falls within the same statutory bar, an interpretation that treats the entire decision-making process as legally inseparable from its outcome for purposes of this specific review provision. Under any reasonable dictionary definition of the word, he wrote, the review bar covers not just the destination but the entire road that led there, a metaphor that captures the practical effect better than the dry statutory language itself does. Chief Justice Roberts and Justices Thomas and Kavanaugh joined that reasoning in full. Justices Gorsuch and Barrett joined most of the opinion as well, rounding out a 6-justice majority on the ultimate outcome. Though the internal breakdown of exactly which justices joined which specific section of the opinion is itself a minor signal that even within the majority there was not uniform enthusiasm for every piece of the reasoning. On the constitutional claim, the equal protection argument specific to Haiti, the majority did not rule it was completely barred from any review, unlike the process-based claims. Instead, it concluded that claim was unlikely to succeed on its own terms, weighing the administration's simultaneous termination of TPS designations for 13 different countries as a race-neutral explanation for the timing and pattern of the decision. This is a legally important distinction. The court did not say courts can never look at whether a TPS termination violates the Constitution. It said that, looking at this particular record, this particular claim was weak enough that it did not justify blocking the termination while the broader litigation continues. The district court that had originally blocked the termination reached the opposite conclusion on this specific point, having cited public statements from both the President and Secretary Noem about Haitian immigrants that the judge read as evidence of discriminatory intent. The Supreme Court's majority did not declare those statements irrelevant. It weighed them against the broader context of the 13-country pattern and reached a different conclusion about the overall strength of the claim, a genuinely closer legal call than the public framing on either side has generally acknowledged. It is also worth noting precisely what the majority left open here, rather than closed off. The opinion states the constitutional claim will likely fail on the current record, language that leaves room for the claim to be developed further on remand with additional evidence rather than declaring it dead permanently. Advocacy groups seized on this distinction quickly, pointing out that the court did not find Haiti or Syria safe to return to, and did not rule the discrimination claim meritless as a matter of law, only that it was unlikely to succeed well enough on this record to justify blocking the termination while litigation continued. That is a materially different and considerably narrower statement than either the celebratory or the alarmed public reactions to this ruling have generally conveyed. Justice Elena Kagan wrote the dissent, joined by Justices Sonia Sotomayor and Ketanji Brown Jackson, the court's current liberal wing on most closely divided cases, and her argument is worth understanding on its own terms, rather than as a simple political objection. Kagan's position is that Congress cannot plausibly have intended, through one narrow statutory provision, to insulate literally every procedural decision the Secretary makes from any court review whatsoever, regardless of how flawed the process or how serious the allegation of discriminatory motive. Reading the bar that broadly, in her view, converts what should be a limited restriction on relitigating the Secretary's substantive judgment call into something closer to total immunity from the ordinary checks that apply to nearly every other exercise of executive power in American government. The majority did not dismiss this concern as baseless. Alito's opinion directly acknowledges that its reading could, in theory, shield real abuses, an arbitrarily short designation, or a termination decided by nothing more than a coin flip, from any court correction at all. But the majority's answer to that concern is that fixing it is a job for Congress, through legislation narrowing the review bar, not a job for the court to solve by reading the existing statute's text more narrowly than it was actually written. That disagreement over whether courts should read an ambiguous statute narrowly to avoid a troubling result or read it as written and leave the fix to the political branches is a recurring fault line in how this court approaches statutory interpretation generally, well beyond this one case. It shows up in tax law, in environmental regulation, in labor disputes, essentially anywhere Congress has written a broad grant of executive authority without spelling out every limit in exhaustive detail, and watching which justices land on which side of that fault line in a given case is often a better predictor of the outcome than trying to guess based on the specific subject matter alone. Let me clear up two misreadings of this ruling that are already circulating because both of them overstate what 6 justices actually agreed to. The first is the claim that the Supreme Court itself ordered Haitian and Syrian TPS holders deported. It did not, and this distinction is not just technical hair-splitting. The ruling addresses only whether a federal court can review the Secretary's decision to end their status. It does not itself initiate or order any individual removal proceeding, which would still have to follow its own separate legal process with its own separate protections. The second misreading is the claim that this ruling ends TPS for every remaining country immediately and automatically. It does not directly, though as I will get into, its reasoning makes that outcome considerably more likely for several other countries over time. Precision matters here specifically because so much of the coverage of this case, on both sides of the underlying policy debate, has compressed a narrow statutory holding into a much broader claim than the opinion itself actually supports. And precision is exactly what gets lost when a headline has to fit in a single line of text designed to be read in half a second while scrolling. Here is the part of this ruling that connects directly to elder care, and it is worth walking through the actual mechanism rather than just asserting the connection. The immediate practical effect of the ruling is that DHS can now proceed with ending TPS and work authorization for roughly 350,000 Haitian nationals and roughly 6,000 Syrian nationals, with USCIS currently directing employers to treat July 1, 2026 as the work authorization expiration date on federal employment verification paperwork, though DHS retains some latitude on exact sequencing and at least one administrative extension to July 10th for some Haitian holders has already been reported since the ruling. Haitian immigrants specifically are heavily concentrated in healthcare and long-term care roles in this country. Leading Age, the national association representing nonprofit senior living providers, has said legally authorized caregivers make up 8% or more of the entire workforce in some of its member communities, describing the situation candidly as one where there is no workforce waiting in the wings to absorb a sudden loss of staff at this scale, a phrase its leadership used specifically because healthcare has been the fastest-growing sector of the American economy for years running and already carries a higher vacancy rate than nearly any comparable industry, meaning the ordinary remedy of simply hiring replacements on short notice is far harder here than it would be in a lower-skill, higher-supply labor market. The American Seniors Housing Association issued a parallel warning specifically about long-term care staffing. This is not a side effect anyone had to speculate about after the fact. It is a direct, foreseeable consequence of how concentrated this particular immigrant population is within this particular sector of the healthcare economy, and it is exactly the kind of consequence that a purely legal analysis of the word determination would never surface on its own. The ruling's reach extends well beyond the 2 countries actually named in the case. Because the court's holding interprets the TPS statute's judicial review bar generally, not in a way specific to Haiti or Syria's individual circumstances, it substantially weakens pending legal challenges brought by TPS holders from at least 9 other countries: Burma, Ethiopia, Nepal, Somalia, South Sudan, Venezuela, Yemen, Honduras, and Nicaragua, collectively affecting close to 1.3 million people across 17 nationalities in total once every pending case is accounted for. TPS designations that remain currently valid and are not immediately affected include El Salvador, running through September 9th, Sudan and Ukraine, both running through October 19th, and Lebanon, running through November 27th, though the legal ground underneath every one of those designations has shifted following this ruling, since any future termination attempt for those countries would now face the same narrow judicial review standard. Given that several of those nationalities also have meaningful representation in caregiving professions in specific regions of the country, expect this exact elder care staffing story, industry warnings, facility-level scrambling, workforce shortfall projections to repeat itself as each additional country's litigation resolves over the coming months, essentially guaranteed by the legal mechanics of this ruling rather than merely possible. Any senior living operator or health system with a geographically diverse workforce, drawing staff from Venezuela, Honduras, or Nicaragua alongside Haiti and Syria, now has good reason to treat this as the first of a series rather than a single isolated event limited to the two countries actually named in this specific case. Ohio is a useful case study for how fast the practical consequences of a purely statutory ruling can cascade into everyday life, because the state is home to two cities, Springfield and Columbus, with unusually large Haitian populations concentrated in caregiving and manufacturing work. Advocates there have flagged that losing work authorization does not just end a job, it can end the ability to legally drive within days, since many states tie driver's license eligibility directly to proof of current federal work authorization, with some residents facing a cutoff for renewal as early as July 6th. For a home health aide who drives between several senior clients' residences each day, the license consequence often arrives before the employment consequence does, which means the actual disruption to a specific elderly client's care can happen faster than the headline timeline of the ruling itself would suggest. This is the kind of second-order effect that a purely doctrinal reading of the case, focused only on the word determination and the scope of judicial review, will never surface, and it is exactly why the legal mechanics and the human impact have to be read together rather than as two separate stories. There is one more piece of this that deserves attention because it is the part most likely to actually change the outcome here, despite the ruling itself being final on the judicial review question. Congress retains full authority to legislate a different result, and the majority opinion itself explicitly says so, noting that if lawmakers disagree with how much discretion the statute gives the Secretary, amending the statute is squarely their tool to use, not the courts. That is not a hypothetical possibility sitting on a shelf. Earlier this year, a group of House Republicans, including Congressman Mike Lawler of New York, broke from their own party to help pass legislation extending Haitians TPS protection through April of 2029, a bill that passed the House but has not yet received Senate action or become law. Lawler has publicly described the elder care and health care consequences of ending TPS as a looming crisis, a notable position from within the president's own party, and it illustrates something worth remembering about how this issue actually breaks down politically once it moves from the abstract to the specific. National polling and party platforms tend to describe immigration policy in broad, categorical terms, but a member of Congress whose own district includes hospitals and nursing homes staffed partly by TPS holders is looking at a very concrete local staffing problem, not an abstract policy position, and that gap between the national framing and the district-level reality is exactly why this bill picked up votes that a purely party-line prediction would not have anticipated. Leading Age and other senior care advocacy groups have specifically pressed the Senate to take up that bill in direct response to the workforce disruption this ruling is now accelerating. The legal question is closed. The political and legislative question is not, and it is the piece actually worth tracking if you want to know whether today's staffing warnings become tomorrow's staffing reality or get resolved through congressional action instead. Step back and look at what this case actually demonstrates about how the Supreme Court currently operates in cases involving executive branch discretion over immigration. The court was not asked and did not decide whether ending TPS for Haiti and Syria is good policy, whether the underlying safety assessment was accurate, or whether the administration's broader immigration approach is sound. It decided a narrower, more technical question: how much power one word in one statute gives to one federal office, and it answered that question by reading the text broadly and pushing the policy disagreement back toward Congress, where the majority believes it constitutionally belongs. Whether you find that approach reassuring or alarming likely depends less on how you feel about TPS specifically, and more on how you feel about how much deference the judicial branch generally owes the executive branch on matters of foreign policy and national security judgment. A much older and broader debate that this case is simply the latest chapter of. That framing matters because the next time this exact fight resurfaces, and given the 9 other countries with pending TPS litigation, it likely will resurface soon, the outcome is now considerably more predictable than it was before June 25th. Precisely because the word determination has been defined this broadly once already. The court reversed the lower court's orders and remanded both cases for further proceedings consistent with its opinion, which is a more open-ended outcome than a simple, straightforward win might suggest. Remand means the cases go back down to the lower courts, not to reconsider the process-based claims the Supreme Court just closed off, but potentially to further develop the narrower constitutional claim the majority found weak on the current record rather than dead as a matter of law. In practice, this means the litigation is not entirely finished, even though the practical outcome DHS moving forward with the terminations is now essentially locked in regardless of how that remaining thread plays out, since the court declined to keep blocking the terminations while it does. If breaking down the actual legal reasoning instead of just the outcome was useful, hit like so it reaches people trying to understand this ruling at more than headline depth, and subscribe if you have not, because both the Senate's response to the extension bill and the string of pending TPS cases for other countries are still working through the system. And each one is going to matter for a different set of families and a different set of care facilities. Tell me in the comments whether you want the next video to go deeper on the Senate legislation or to cover how one of the other pending country cases, Honduras or Venezuela in particular, is likely to play out now that this precedent is on the books, because both of those threads are moving right now, and each one affects a genuinely different set of families, workers, and facilities than the Haiti and Syria story we just walked through.